Next case to come before us this morning is Phoenix Lighting Group LLC, which is Genlyte LLC. Each party will have 15 minutes in which to present their case. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and you wish to reserve that time, please let me know when you come to the podium. I'm keeping track of the clock and keep you apprised of passage of time. We are being visually audited, recording and posted online, so please try to remain behind the podium as much as possible. We have ready to proceed when you are.
Good morning, Your Honors. May it please the Court. I am Aaron Persig for appellant Genlyte Group LLC, which is referred to throughout this case as DCO. I'd like to reserve 3 minutes, Your Honor, for rebuttal. And I hope that I can address 3 issues with you here today. Our briefs go over a number of errors that we think require not only reversal for a new trial, but judgment in my client's favor. The 3 I'd like to focus on with you are first, the trial court's error in excluding evidence of the results of Appellee Phoenix's mitigation efforts. 2 different trial judges have already reached opposite conclusions regarding whether to admit this evidence of mitigation efforts. First, Judge Rowlands in the initial trial agreed to admit it. Appellees immediately voluntarily dismissed their case thereafter. And indeed, Judge McCarty in the second trial, on which we are here today, was herself of 2 minds on the issue. To quote her, she changed her mind 2 weeks into the trial, reversing course and not allowing the mitigation evidence to come in. The second issue I'd like to address is the trial court's denial of our motion JNOV and new trial because there was insufficient evidence here that my client DCO committed any of the torts or conspired with anyone to commit any torts. The result of what the trial court has done is to fundamentally alter competition law here in Ohio, and this court, I think, needs to correct that to prevent what could be broad economic consequences. The third issue has 2 parts. The first is that the trial court allowed the jury to find conspiracy damages on top of the damages for the underlying torts that they found. Conspiracy, of course, simply expands the number of parties who are liable for a tort. It does not increase the damages. And second, Appellee Phoenix admitted that it could prove no more than a certain amount at trial, and yet the jury came back with a higher amount. That amount should have been remitted as well. So taking the mitigation issue first, this case arises from the action of 2 former employees of Phoenix Lighting Group, Jason Brown and Guy Day. Phoenix is one of 2 lighting companies owned by Patrick Duffy. Phoenix sold lighting under the Acuity brands in Cleveland. Jack Duffy and Associates, the sister company, sold in Akron. They're both plaintiffs here. The essence of the claim is that Brown and Day sought to destroy the Phoenix business by starting a competing firm. How did they do that? Allegedly by stealing away employees and by using confidential information of Phoenix. They then claimed that my client DCO was conspired to make that happen. Importantly, there was one theory of damage in this case, which is that the day after Brown and Day left Phoenix, the value of Appellee Phoenix went from around $1.315 to $1.4 million to near zero. Within a day of their resignations, Mr. Duffy, the owner of both companies, sent a letter to all of his customers and suppliers for both companies on joint letterhead, explaining that he was unifying, in our view consolidating, these 2 companies and the operations therein on April 1st. Mr. Duffy made no meaningful effort to keep the Phoenix operations going, and Duffy and Associates paid essentially nothing for Phoenix on April 1st. The suit was also filed initially on April 1st as part of that entire effort. I think what you'll see, what you've seen after briefing is on this mitigation effort where Phoenix really criticizes us is on the quality of our evidence. I think that there is generally agreement that mitigation occurred, the jury found as much. The problem is that we were excluded, the evidence that was excluded was evidence that would have showed our theory of why there were no damages. There was complete mitigation. That comes up in many ways. The first and most important part is that our expert, Mr. Fudo, was prevented from giving his opinion. His opinion would have shown that the combined Phoenix and JDA entities made about as much money as the entities did when they were separate. We also would have submitted Mr. Duffy's tax returns as the sole owner of 2 LLCs. The distributions from the companies flowed through to him, and you would have seen, the jury would have been able to see that the separate companies, Phoenix and JDA, made about as much money as the combined entities did. The ruling of the court was really quite sweeping, and again, it came in the middle of trial. You'll find it at 12:01 to 12:10 of the transcript. We also the jury was permitted to hear that after February 18th, when Mr. Duffy announced that he was closing Phoenix, experienced lighting employees came to him and asked to be hired for Phoenix. He chose not to do that. He instead hired them for JDA. The jury was not allowed to hear where those employees were hired for. They weren't allowed to hear that they went to JDA. The jury is left with this idea that Phoenix was going out of business. They are left with some mitigation evidence. We are never allowed to explain what the results of that mitigation would be, and we believe we would have been able to show complete mitigation. As I said before, their theory of the case is that within 6 weeks, the value of the company went from $1.315 million to zero. We were not allowed to test that theory. We think that's a very simple error for the court here, and it leads to a new trial. The second set of issues that I'd like to address are the insufficiency of the evidence here. This case is pretty unusual in its theory because when you look at case law regarding this idea that a company is trying to destroy another, you see breaches of fiduciary duty by partners at a law firm. You see stealing of clients, of customers. None of that happened here. What you have are two individuals, Brown and Day, who wanted to buy the business of Phoenix. When they weren't able to do that, they went out and sought their own way to start their competing firm. Brown and Day and all of the employees of Phoenix are at-will employees. They have no non-competes. They could be fired any day for any reason, and that means they could leave any day for any reason, and that's the bargain that we give employees in Ohio when they are at will. If someone wants to have a non-compete, they typically have to pay more to keep those employees around. The allegation here is that the business was destroyed by stealing the employees. Brown and Day leave and encourage other employees to go with them. These aren't employees to steal, Your Honors. These are employees with at-will agreements. These are employees without non-competes. These are employees who are free to go other places. And in fact, Phoenix had hired employees with experience from other places to come join it. Competition law in Ohio has been defined in the restatements, Second of Torts, Section 767 and 768, which explain that there is, of course, a privilege to compete. Competing entities, it may be nasty sometimes. Competition can be ugly, but that is what we want in Ohio and in our free market system because it leads to lower prices, it leads to innovation, it leads to greater output, and importantly, on the employee side, it allows employees to move from one company to the next, something they have the perfect right to do unless they have a non-compete. So how does DCO fit into to what happened here? The allegation is that Brown and Day left, took employees with them, and used confidential information. DCO is accused of getting a business plan, that they should have known from that business plan that confidential information was being taken, that they should have known from that business plan that employees were leaving unlawfully, when in fact the assumption is that at-will employees can leave lawfully. And then they went out and they gave a loan to the plaintiffs for the purposes of helping them start their new business. It should not be the rule in Ohio that competitors can't do those kinds of things. And in fact, it's not the law in Ohio to do that. Looking briefly at the tortious interference claim, the idea that DCO somehow interfered with the relationship between Phoenix and its employees. Again, these are at-will employees. They can leave at any time. They can be fired at any time. There is no tortious interference in a case like that, absent non-competes. There's a trade secrets claim. The trade secrets come in really two forms. One is an employee list. The evidence shows, and it's undisputed, that the list of employees, which was the names of employees, their years of service, Phoenix published on its website, not a trade secret. It may have been information that Phoenix wants to claim as confidential, but when you publish it on your website, it's not confidential, and it's certainly not a trade secret. The Fred Siegel versus Arter and Hagen case, of course, talks extensively about the business on their own or not. Trade secrets, and I think it's quite easy to see in a situation where the information has been published that it's not a trade secret. Sales information. Phoenix claims that Brown and Day took sales information and gave it to DCO as part of this conspiracy to compete. First of all, the evidence refutes that. If you look at Joint Exhibits 124 and 125, or the transcript at 706 and 708 and 1221 to 1222, it's plain that the information was not Phoenix information that DCO ultimately received. There is no evidence that DCO asked for Phoenix's information. What we're really left with here is the idea that a business like DCO, a competitor of Phoenix's suppliers in the marketplace, has to somehow assume that someone who brings it a business plan is using illegal means to create that business plan. That's the assumption that we are left with here, and that can't be the law in Ohio. Imagine a bank or an investor or a business partner having to assume from the beginning that an experienced employee coming over from a competitor is doing so unlawfully. The law has always looked at that exactly the opposite way. Civil conspiracy. The notion is, again, that DCO somehow conspired with Brown and Day because it received the business plan. The evidence simply doesn't support that here. We received the plan. We ultimately decided to loan them money. But for us to have to assume that Brown and Day were acting tortiously, I think is, again, not supported by Ohio law. And none of the cases in Ohio would say otherwise. My client is privileged to complete unless they engage in what is called a malicious combination as a conspiracy. They didn't do so here. What's remarkable here is also moving to the damages side. At the most, this was a $1.3 million case, as according to plaintiff's evidence. We end up with a $10 million verdict when you include attorney's fees and a multiplier on attorney's fees. That's an extraordinary result for a company that at most was worth $1.3 million.
You're approaching your 3 minutes. So you may proceed if you want to.
I will simply conclude, Your Honor, that you'll see in the record very clearly that conspiracy damages were awarded on top of the tort damages. You can't do that. And at closing, Phoenix said that it could not prove more than $1.4 million in damages. When the jury exceeded that cap, the trial court should have permitted the damages. And I'll reserve my time. Thank you.
Good morning, Your Honors. If I could get a warning with 2 minutes, I would appreciate that. My name is Jeff Witchey. I'm here today with Betsy Hartshoe on behalf of Phoenix Lighting Group and Mr. Patrick Duffy, who is here as well. Today we defend a jury verdict against an industry giant that was not just a victory for Phoenix Lighting, but was a message that was sent to an entire business community, making it a fairer environment for its law-abiding participants. The first topic I'd like to discuss with you today is a contention that DCO makes that they were not allowed to present evidence regarding this so-called consolidation. And I refer to it as a so-called consolidation because by the time of the intended consolidation date, we had presented evidence, we had made the argument, and the jury accepted it, that by the time of the consolidation, there was nothing left of Phoenix that it could consolidate with. DCO argues that it was not allowed to introduce evidence regarding the disposition of the vendor contracts, the sales territories, the distributor and employee relationships, and that Jack Duffy and Associates did not pay any money to Phoenix. It was allowed to present all of this evidence. The record completely belies these contentions. In fact, that was the focal point of DCO's defense. It's bewildering to me that they argue that because the record verifiably proves that that was not the case.
Well, I think that they're arguing, one of the things they're arguing is their expert wasn't able to like summarize it all and put it all together and to help the jury understand all that evidence.
Right, okay, so that takes me to the very next topic. What is it that they were not allowed to present evidence of? And the only thing they were not allowed to present evidence of was the subsequent year's revenue totals for Jack Duffy and Associates. And that was for good reason. The law provides, first of all, that when a business is destroyed, the damages are the value of the business before the tortious conduct minus the value of the business after the tortious conduct. We had an expert witness, and we had Mr. Duffy, an industry knowledgeable person with decades of experience, and even Mr. Breckner, who was an employee that was industry knowledgeable, and they all talked about this valuation. Mr. Zalesnik, the expert witness, put a valuation on it before the tortious conduct and a valuation on it after the tortious conduct. And in essence, what he said was, what would an industry knowledgeable person pay for this business before the tortious conduct? What would they pay for it after the tortious conduct? And he said that there was just a de minimis salvage value that would be left at that time after the tortious conduct. Those three witnesses all specifically looked at individual items that DCO argued should have some value. They looked at the vendor contracts. They found that those are 30-day contracts, that they're non-assignable, that there's no value there. There's nothing for Phoenix to sell. The vendor owned the territory, not Phoenix. They looked at the distributor relationships. The distributor relationships were purchase order based. It's a relationship no different than the one that I've got with Giant Eagle. I step up to the cashier's counter with a gallon of milk, and I pay my money and I walk away. Anybody was free to do that. Anyone was free to buy products through distributors. There was no value there. They even looked at the three remaining employees. And what Mr. Zalesnik said and what Mr. Duffy said was those three employees don't have any saleable value. They are no longer part of a trained and assembled workforce that's part of a going concern business. You could hire them, you could pay them salary, but nobody was going to go to Phoenix and offer Phoenix any money for those three employees. It was not an asset that Phoenix could sell. Now, against this, DCO refused to do a valuation. They didn't value the business as a going concern either before or after the torts. They never took a look at the individual assets. No industry knowledgeable person ever said that these vendor contracts could be worth something. And the jury believed Phoenix's evidence on this topic. Instead, what DCO did is it hired an expert witness to look at the total revenue of Jack Duffy and Associates 2 years after the fact. And this information was unparsed, undistinguished financial information, the kind that you get just out of the company's financial statements at the end of the year. And they argue that somehow Jack Duffy and Associates' total revenues can mitigate Phoenix's damages. There's a lot of problems with this. First of all, Jack Duffy and Associates and Phoenix are separate legal entities. And we asked DCO to come up with authority, and so did Judge McCarty. Asked DCO to come up with authority that allows them to disregard the separate legal existence of these two companies. They could never do that. They would throw up in anemic fashion the de facto merger doctrine or the alter ego doctrine. But these doctrines are equitable doctrines that are available to creditors to prevent debtors from defrauding them by using corporate shell games to hide assets. And the first thing we know is they're equitable doctrines. You have to come to court with clean hands to engage the court's equity, and not the bloodied hands that DCO has. Certainly, these equitable doctrines are not meant to be used by a malicious, intentional tortfeasor to somehow gain pardon for the damages and injury they caused an innocent victim. Then, even if you're going to accept that this somehow is the same entity, that there is no separate legal existence to these entities. This is just not proper mitigation to begin with. Mitigation is a concept of avoiding or preventing the accumulation of future or additional damages. It's not rebuilding something already destroyed. It's not repairing something already damaged. Perhaps the best way to explain this is to take an analogy. Let's suppose that instead of a lighting agency, Phoenix Lighting was a winemaker, and it has a wine vat. And DCO comes along and they poke a hole in the side of this wine vat. Now the amount of wine that's above that hole at the time that Mr. Duffy or someone from Phoenix realizes there's a hole in the side, one of two things can happen with that. Either they can plug the hole and mitigate the damages, or they can fail to plug the hole and then it goes out on the floor. But prior to that time, any of the wine that actually came out and hit the floor is contaminated and it's done. There is damage there. But for the wine that was above, it's either going to be mitigated or it's failed to be mitigated. In either case, you can't recover the damages for the wine that was above at the time that you realized you could have plugged the hole. But here's the thing. In this case, they didn't poke a hole in the side of Phoenix. They came in with sledgehammers and they destroyed the wine vat to smithereens. So then Jack Duffy and Associates, a company, a separate legal entity, separately operated company, had the ability to rebuild this wine vat. And they did so over the course of the next 2 years. Now DCO comes in and looks at the wine vat 2 years later and says, what's all the fuss? Why are we liable for that? You still have your wine vat. You can see where this is a logically bankrupt argument. And it actually feeds into the law on mitigation. First thing we know about mitigation is it's an affirmative defense. They have the burden of proof on it. They have to come forward with proper evidence showing that there was mitigation. And because they are an intentional tortfeasor, and if they're using this as an affirmative defense, we know there's liability and we know there's damages. They're just trying to mitigate those damages. At this point in time then, they have to show, because they're an intentional tortfeasor, first of all, the concept of mitigation is going to be strictly construed against them, narrowly against them, and in favor of the plaintiff. And then you get to the next rule that mitigation has to arise from transactions related to the breach or tortious conduct. DCO admitted before trial. Its expert admitted. They could relate no sale, no opportunity, no relationship, no discrete portion of income, no success, nothing, back to the Cleveland market, let alone back to Phoenix, or some opportunity that was available because of the wrongful conduct. So Judge McCarty could see exactly what it was DCO was doing here. DCO could not analyze the Cleveland market. They could not, they knew that Jack Duffy and Associates, the successes that it had in other markets, the income it was making from other markets, could hide and mask the utter devastation that they caused to sales in Cleveland. And Judge McCarty was very patient with respect to her decision-making on this. She warned them, contrary to what they said this morning, contrary to what they said in their brief, she warned them in January, 4 months before the trial started, that she was likely going to be ruling that these are separate legal entities, and she was going to respect that. So there was no sideswiping of a decision here. After 2-3 weeks into the trial, she could see that they were using this evidence to try to mask and hide the damage that had occurred in Cleveland. I'd like to talk a little bit about the tortious interference. Essentially what DCO did this morning and what they did in their brief is they tried to downplay or marginalize DCO's involvement. DCO was fully aware of the unlawful nature of the business plan. You can read the business plan alone, you know that what is going on are breaches of fiduciary duties. You know there's information being disclosed that shouldn't be disclosed. They were fully aware of the nature of this plan. They systemically and pervasively participated in, developed, encouraged, enabled, funded, ratified, and stood to reap the benefits of this unlawful plan. Using Brown and Day as surrogates to solicit the employees is not a defense. And sure, there is in Ohio and other states that accept the restatement of torts on this, there is a concept of competitive privilege. Fair competition privilege is what it's called. But that requires there to not be any improper conduct. And then there's indices of improper conduct. And those indicators are things like a mass rate of employees. We have that. Simultaneous no-notice resignation of key employees. We have that. Breach of fiduciary duties. Excessive benefits. Attempt to conceal conduct. Misappropriation of trade secrets, and intent to harm. Here they were going to knock us, take our workforce and knock us out in one fell swoop. These items, that alone is actually sufficient in and of itself for there to be a finding of improper conduct. I'd like to address our cross appeals for a minute. Judge McCarty issued the ruling with respect to punitive damages regarding the direct misappropriation of trade secret claim. She found that statute would allow for treble damages under 1333.63B and offered what would be the maximum if it were a treble damage statute. However, it's not a treble damage statute. It's a 3 multiplier against compensatory damages for the cap. So you get both compensatory damages and you also get a potential award of up to 3, for punitive damages of up to 3 times the compensatory award. The notion that Judge McCarty referred to it and treated it as a treble damage and then issued the maximum amount leads me to believe that if under the proper statute she would have a proper interpretation of the statute, she would have likely granted the full amount, the full $300,000 additional punitive damages. Additionally, for the conspiracy claim on misappropriation of trade secret, again rooted in the statute where the General Assembly wanted there to be a 3 cap, unfortunately a 2 cap was applied.
That is what you got.
All right, thank you, Your Honor.
Your Honor, approximately how much?
2 minutes and 40 seconds.
Thank you, Your Honor. Simply to address the cross appeal very, very briefly, that argument was made back to Judge McCarty. She reconsidered it carefully. She continued to give the damages she gave. I think that's a very easy error to reject. A few things. On mitigation, the idea that Phoenix is endorsing is that if someone harms you, you can immediately decide to close your company, move everything to a new company, and claim complete damages for the loss of the first company. You could even set up a new LLC the next day and say, I'm starting a new business all over again. What we have here, what the evidence shows, what our evidence would have shown if we had been allowed to give it, is that all of the customers from the Phoenix territory, but 2, Mr. Duffy testified in his deposition, did end up going to JDA. The Cleveland area that they served was serviced then by JDA. JDA had been in Akron, Phoenix, in Cleveland. Now both territories were served by one company. The remaining employees went with Mr. Duffy to JDA. Employees were came to Mr. Duffy for jobs and said, we'd love to work for Phoenix, we can help you do this. He said, nope, I'm closing it, because remember, he had voluntarily decided to unify the companies, that's his word, unified the companies. You want to call it something other than consolidation, okay, but he said he was unifying these two companies to everyone in the world that mattered to him, his customers and suppliers, the day after Brown and Day resigned, and then tries to pin on Brown and Day and eventually my client, someone who's just trying to compete in the marketplace, looking at a business plan and eventually making a loan, trying to pin on them his decision to voluntarily consolidate, and then say, by the way, judge, by the way, jury, you can't look at the results of that consolidation. You can't look and see, you can't test the theory that they had. Their expert does have a theory that within 6 weeks there was no value left. Our expert had a theory that no, there was, and you know how you know? Because when they consolidated, when they unified JDA and Phoenix, those companies ended up with the same revenues, the same clients, the same territories as before. We didn't need to parse through which contracts, because the testimony we would have been able to give, had the judge not ruled the way she did, was that all but potentially 2 of the customers came over. That, plus the expert report, is enough for a jury to be able to say that there were no damages here, or to figure out something in between, but to suggest that my client, who these 2 employees came to, this was Brown and Day's idea, the testimony was very clear on that, they came to us with a business plan and asked for a loan to start a competing company. To suggest that my client somehow had responsibility there, I think really does set competition law on its head in the state, and it's extremely problematic going forward.
You're out of time.
Thank you, Your Honor.
Thank you. Thank you for your presentations today. The court will take your other advisement and will issue a written decision which will be on both sides as well as